Appeal in and for the 5th District of the State of Florida is now in session. The Honorable Carrie I. Evander, Chief Judge presiding. All persons having business before this court draw near, give attention, and you will be heard. May God save the United States of America, the State of Florida, and this honorable court. Please be seated.
Okay, good morning. I've already been introduced. Let me go ahead and introduce the other members of the panel. Seated to my right and your left is Judge Meredith Sasso, and then to my left and your right is sitting as the senior judge is Judge Bruce Jacobus. We have one case scheduled for today. Each side will have 20 minutes. As far as the appellant, you're entitled to divide this time into an initial argument and a rebuttal argument after the opponent has spoken. Just let me know how much time you wish to reserve for rebuttal, and I'll try to help you in that regard. If you have a cell phone or any other electronic device, make sure it's in the silent mode so that the oral arguments are not disturbed. You can go ahead and check if you want. Actually, I think I need to check too. So.
Yeah, I checked mine. That was for you.
All right, we'll go ahead and take up the case of Auto Club Insurance versus the State of Norman Lewis.
Good morning. May it please the court, Wendy Loomish and John Atkinson here for Auto Club Insurance Company of Florida. I'd like to reserve 5 minutes for rebuttal.
All right, you may proceed.
This case presents a single legal issue concerning the interpretation of an insurance policy. Where a policy provides coverage to a person who suffers a bodily injury, can the parents of the one person who was physically harmed recover additional per-person limits for their loss of consortium? Under the plain language of the policy and under established Florida law, the answer is no, there is only one per-person limit applicable in this case. The policy here defines bodily injury as bodily harm, sickness, or disease, including death therefrom. The plain meaning of bodily injury is physical harm. Established law, we've cited probably 8 or 10 cases in our brief that all support that, and in fact, the estate does not seem to dispute that under the definition section of the policy, there is no per-person limit for separate per-person limit for loss of consortium. What the estate is saying is that the limit of liability section of the policy makes a change, but it does not.
Let me ask you this. Let me say this is the hardest policy I think I've ever read. I mean, because it's a package policy. So one minute, you're talking about cars, and next minute you're talking about sinkholes. Then there's stuff about your dogs in here. I mean, it's very complicated, but let's get right down to it. On the limits of liability, what do you think it means, in number 1B, any other person?
I think that what that language is saying, if you read I think you need to read the full policy.
Really, bodily injury to one person includes damages for care, loss of consortium, or loss of service sustained as a result of the same injuries by the injured person, correct? And then any other person.
In other words, that other person, for example, on a loss of consortium, is subject.
Would that be the parents?
Yes, would be subject to the same limit. And I think you have to look at the error that the court made was not looking at all of the language of the policy. Bodily injury is a defined term, and in this section of the policy, if you notice, it's all in italics to reflect that it's defined.
Can the injured person have loss of consortium?
No, what the policy is saying is the injured person, the person who has a bodily injury.
Can the injured person have loss of services? I suppose.
What it's saying, as all policies have interpreted it, is that there's one person who has a bodily injury who suffered physical harm. If there are others who suffered a loss of consortium, that falls within the same policy limit.
You would agree that or loss of consortium or loss of services could only be the other person, correct?
Where there is a bodily injury to one person. The issue is, can you get a separate can you get a separate coverage for that? And the answer is no. It's always framed by bodily injury. So if
How about the word care? How about the word care? Bodily injury to one person includes damages for care, loss of consortium, or loss of services sustained. So loss of consortium is another person. Loss of services, I think you said, is another person. How about care?
I think that could be the injured person or another person. But what the policy is saying very...
How could the other person have care? I mean...
No, the injured, what the language says is bodily injury to one person, so that the person who suffered physical injury can include the damages for that person's care.
It
can
include.
It includes damages for loss of consortium. It includes loss of services, but only under a limit of liability for the one bodily injury. And if...
Isn't that what now Justice Polson was getting at in his dissent in Reese?
I think the point here is that you go to the definition and you look at bodily injury, and once you look at the definition of bodily injury, everything flows from that definition of bodily injury. And all of the cases have said that. What's interesting is the plaintiffs have not cited the estate has not cited a single case supporting their interpretation. In order to get to the argument that they want to make, they had to go outside of Florida and find a series of cases where the definition said that bodily injury included loss of consortium. And every case that interpreted those 4 cases said definitions are different.
Oregon has good law, I think, don't they?
There's nothing wrong with Oregon. The point is that in Oregon, the policy said the definition was loss of consortium. And those two concepts are not the same. In fact, what's particularly telling is if you look, the estate liked to use charts in their brief, but if you look at their chart where they try to compare cases, they compare the out-of-state case, the definition section, to a limit of liability in our policy. Completely different. You have to start with the definition, and that's one of the things I think the court overlooked. Every case that has addressed the issue, I can't emphasize it enough, every case that has addressed this issue has said bodily injury is physical harm. It does not include a loss of consortium. And nothing is changed about that by virtue of the limit of liability. In fact, it's also telling that the estate conceded, I believe in their brief, that if the term bodily injury to one person was in quotation marks in that second sentence, then it would be clear. They suggest that in their brief because we use quotes to try to point out to the court the phrase we were talking about, and they criticize us for that and then say, but if it had the quotes, it would be perfectly fine. Why are the quotes needed? It says bodily injury to one person. They're defined terms. They're in italics and bold. The estate also takes out the to one person when they try to make their argument. So all the things that they're trying to argue to the court are really strained interpretations because they recognize that the cases have all held the same thing. There is one physical injury in this case, and all of the damages that flow therefrom, whether loss of consortium or otherwise, are limited by that per person limit for the one bodily injury. So we would ask that the court reverse and that the court find the per person limit for bodily injury includes loss of consortium, and it does not provide for a separate limit. Unless the court has additional questions, I'll reserve my time for the rebuttal.
All right, thank you. All right, for the appellee.
Good morning. May it please the court. Jessica Connor on behalf of the estate of Deputy Norman Lewis, the appellee. Also here today is my client, the personal representative and the mother of Deputy Lewis, personal representative of the estate, Norma Jean Lewis. Auto Club has not shown that their interpretation of the policy is the only reasonable interpretation of the policy. Nothing that they have argued precludes the interpretation that was found by the trial court and by other courts across this nation. I want to point out an incorrect statement that was made by counsel today, and also an incorrect statement made in their initial brief. They repeatedly state that the cases that the estate has relied on from Oregon, from Maryland, so the Handguard case, the Valier case, they state that in those cases, the policies in the definition section define bodily injury to include loss of services. That's incorrect, and I will read from the Giardino case, the Illinois case, that followed the Oregon case.
What do you think? I mean, I've read this thing many times, over and over. You know, bodily injury, which is a defined term, then it says to one person. Well, that's a human, according to the. That's good to know, because there's dogs in here too. You know, German Shepherds. I mean, it's incredible. But includes damages for loss of care, loss of consortium. The injured the person that was injured in the accident couldn't have a loss of consortium claim, correct?
Correct.
So, but they define bodily injury to include the loss of consortium claim. So it would seem, and that would have to be any other person would have that claim, I think.
Correct, Your Honor, and that's the interpretation that the Oregon court that was faced with similar policy language where you have the term bodily injury.
It says the most we will pay for bodily injury to one person, that would be the deputy in this case, in any one accident. It kind of includes, it seems to say it includes the loss of consortium claim, doesn't it? I mean,
Your Honor, it's ambiguous because it's saying the most we will pay for bodily injury to one person. That one person could be the loss of consortium claimant. So if bodily injury is defined to include loss of consortiums, that provision reads, the most we will pay
And
for loss of consortium.
that argument necessitates this limit of liability to be seen as the second definition, doesn't it? As opposed to the type of damages that are available?
Correct. In the limit of liability provision, bodily injury, the definition of bodily injury is expanded to include not just physical injury, but also loss of consortium and loss of services to any other person, the loss of consortium claimants.
You would agree that the series, care, loss of consortium, or loss of services modifies damages, right? It does not modify bodily injury.
I disagree that that's a possible interpretation. It's not the only interpretation. The phrase includes damages for care, loss of consortium, or loss of services modifies bodily injury, which was how the courts in the Handguard case, the Oregon court, specifically said that phrase modifies the term bodily injury. And if they wanted to make it clear.
Wasn't that the phrase includes damages of, the damages of, wasn't that missing from that policy language? In other words, the way that we always read these series is to modify the noun that comes directly before it, right?
That is not, I don't think that that is the only way to construe this policy. I think a normal, ordinary reading of this, you could read bodily injury to one person includes damages for care, loss of consortium, that you could read that to be bodily injury. And if they wanted it to be clear that it was modifying the phrase bodily injury to one person, what they should have done was put it in clear, unmistakable language. Put it in quotes, like was done in the State Farm v. Brown.
Put it in a definition section and define bodily injury as, which is what they did.
They did.
And then when the policy refers again to bodily injury, I'm having a hard time seeing how that series doesn't define the type of damages rather than create a second type of bodily injury.
Because the language itself says bodily injury to one person includes damages for care, loss of consortium, or loss of services.
And so doesn't it come down then to what includes means, whether includes is definitional or whether it's
Includes
what's included in damages?
Includes is definitional,
okay.
And that's stated in the Brown case relied on the Hauser case, the Hauser v. State Farm case, which is another case that the appellant has cited in their brief. And in that case, the court said that when It said the provision defined, quote, bodily injury to one person, end quote, to include all injury and damages to others resulting from the first person's injury. So the fact that the provision said bodily injury to one person includes, they said that was a definition of the phrase, quote, bodily injury to one person, end quote. Using the words includes defined that term, but in that case is distinguishable because they put the phrase bodily injury to one person in quotes to clearly convey that bodily injury to one person was being given a specially defined meaning so that it could be applied into the previous sentence and make sense that the each person limit was intending to limit all damages of everyone, loss of consortium, physically injured. Putting it in quotes made it very clear in those cases.
Let me ask you this. So you're saying that the word, well, what the last part, care, loss of consortium, or loss of services sustained, you're saying there's two reasonable interpretations, one that it modifies damages or one that it modifies bodily injury. Would that be a fair statement of what you're arguing?
Correct, Your Honor.
Okay, and if it modifies bodily injury, then your argument is you win, but if it modifies damages, then that's bad for you. Would you agree with that?
It renders the policy ambiguous, and the court is required to construe it in favor of the insured.
But let me ask you this. If we interpret it to modify bodily injury, would that be inconsistent with the definition of bodily injury found elsewhere in the policy?
It is not inconsistent. It would be inconsistent if this provision said bodily injury no longer includes physical harm. That would contradict the previous definition in the definition section.
Well, if you're saying that bodily injury includes loss of consortium, why isn't that inconsistent with the definition elsewhere where it doesn't have the loss of consortium language?
There's nothing unusual or inconsistent about a policy having modifying or expanding or limiting a definition in different provisions of a policy.
Right, and so that's really your argument, is that you have a definition section of bodily injury, and then you have this limitation of liability, and you're arguing that that section expands the definition of bodily injury.
Correct, Your Honor.
Okay, but if you interpret that limits of liability section that the last part modifies damages, then there's no inconsistency and no expansion. Would that be a fair statement?
The part that says includes damages for care, loss of consortium, or loss of services would have to modify the phrase bodily injury to one person. That's what I think it would have to modify.
But if you do it that way, it's either inconsistent or expands another part of the policy. But if you look at loss of consortium, care, loss of consortium, or loss of services as modifying the word damages, then there's no inconsistency or expansion of the definition of bodily injury found elsewhere in the policy. Would that be a fair statement?
It would not be inconsistent with the previous definition.
If you do it this way, I was just thinking out loud again, but if you said bodily harm to one person includes damages for care, loss of consortium, or loss of services sustained as a result of the same injuries by the injured person or any other person, then it kind of, in other words, bodily harm to one person, there's got to be bodily harm to one person, which would be, the deputy in this case. And then it says includes the damages for, it lays out what the damages are for that bodily harm. That's really what it's saying,
One person is not limited to the deputy. One person is a human being. It could be the loss of consortium claimants.
Then they wouldn't need to say A or B if that was the case. In other words, they'd say the injured person and any other person. All right? There has to be death. In this case, there was a death, but there has to one person, all right? And that, the damages include the damages for care, loss of consortium, all the things they say for the injured person and any other person. It kind of, I don't know.
the way the trial court interpreted it, and the way I would urge this court to interpret it, is that bodily injury includes bodily injury to a person, so it could be bodily injury to the physically injured person, bodily injury to the loss of consortium claimant. Bodily injury includes, that term, bodily injury, includes damages for care for the physically injured person. Bodily injury can be loss of consortium damages, it can be loss of services damages.
I see what you did,
So, let me ask this, if that series is seen as creating a new or expanded definition of bodily injury, is there anywhere else in the policy to look to see what types of damages are available for an injury?
This is the provision that defines what the per-person limits are and how you interpret the per-person limits, who's entitled to the per-person limits, and this is the section of the policy that does that. I wanted to point out that there's nothing inconsistent, I wanted to make clear that Auto Club tried to distinguish the Oregon cases on the basis that the policies there allegedly had the definition sections defined bodily injury to include loss of services. That's incorrect. It actually, in the Giardino case, the court specifically said, in the present case, the parties contest the meaning of bodily injury, a definition of which is contained within the policy's limitation clause. The same limitation clause here. It wasn't defined in the definition section as they have argued. It's just an incorrect statement of the case law. The court clearly said that the definition of bodily injury, which included loss of consortium, was contained within the policy's limitation clause. And in all the other cases that have the same type of language as the Giardino and the Oregon case, that definition was also not found in the definition section. The definition of bodily injury to include loss of services was found in the coverage section. So it's clear that you can define a term in places other than just the definition section, and that's exactly what occurred in those cases. And in the cases that they rely on, as far as the Brown case, the Hauser case, those were the cases that put bodily injury to one person in quote. The court said that that was also a definition of bodily injury to one person contained within the limitation clause. The court said that, clearly stated that the limitation clause defines bodily injury to one person, which is in quotes, to include all injury and damages to others resulting from this bodily injury. So it's clear that you can have a definition, and in those cases, bodily injury was previously defined to include physical injury, but then the limitations section contained a new definition. So you can define terms differently in different sections of a policy, and there's nothing inconsistent about that. Additionally, they state that the policy, the holdings in the Oregon case and the out-of-state cases are widely disfavored. That's not an accurate characterization. It's that the policies in those cases contain completely different language than standard insurance policy language. The language in this case, in the subject case, is completely different from standard insurance language, and that was pointed out in the Valliere case, where the court noted that loss of consortium or other services is not a bodily injury within the meaning of usual insurance policy language, but is a consequential damage resulting from bodily injury to another person. We continue to agree with this interpretation of normal insurance policy language and with the great number of opinions taking this position. In the insurance policy involved in the present case, however, the term bodily injury is specifically defined to include loss of services. The insurer is bound by that definition. That's what's occurring here. This language is not the standard type of language that you see in the 20-plus Florida cases that they cite that have completely different language. They rely on the Hart case, the Geico v. Arnold case, the Clohessy case. Those cases all have very clear but very different language. In those cases, they clearly start off by saying the limit of bodily injury liability stated in the declarations is applicable to each person is the limit of the company's liability for all damages, including damages for care and loss of services. So the including damages for care and loss of services is clearly modifying the per person limit in those policies. They're saying the per person limit includes loss of consortium, loss of services, and they use the terms, it includes all damages. You don't have that type of clear, unmistakable language in the subject policy because the subject policy just says the bodily injury limit stated on the declarations page for each person is the most we will pay for bodily injury to one person. It doesn't include that language about all damages. The limit includes all damages, or that so that all damages, including damages for care and loss of service, is modifying the per-person limit. Instead, you have a second sentence that starts off by talking about bodily injury instead of the per-person limits, like the Hart case and the
But wouldn't it be
Arnold
a
case.
different situation if it said bodily injury is, or bodily injury means, or, there's all sorts of words in the English language that convey a definition rather than the words that convey the types of damages are included.
I disagree, Your Honor. I believe that provision, when you read it, bodily injury to one person includes damages for care. I think that conveys, if Your Honor is inclined to find that their interpretation is reasonable, I think there is a second reasonable interpretation, which is that bodily injury includes damages for care, loss of consortium, or loss of services. And clearly that would have to be the loss of consortium and loss of services would have to be suffered by someone other than the physically injured person. And there are as we've cited, the number of cases that say that a policy can define bodily injury to include loss of services, even though that departs from the ordinary understanding of the term bodily injury. If a policy does that, if it defines it by using the word includes, I don't think it has to be limited to bodily injury means. I think it can be bodily injury includes damages for care, loss of consortium, or loss of services, and to arrive at a construction that bodily injury includes loss of services and loss of consortium. And so I think that is a very reasonable interpretation. That's how the trial court read it. That's how numerous courts, when faced with language that says bodily injury includes damages or means damages for loss of consortium, then that's what bodily injury means. And that means, and if they wanted to make this clear, the burden is on the insurance carrier who drafted the policy to make this language clear and unmistakable. That is their burden. They can't leave their language open to multiple interpretations.
What do you think your best case is?
I would say the handguard line of cases, but also I would say they keep stating that we haven't cited any Florida cases that are on point. Neither have they. All of the cases they cite, yes, they're from Florida, but they are not on point because the language is materially different.
What do you think your best Florida case is?
I would state actually any of the cases they cite, because the cases that they cite, like the Hart case, show how different that language is and how clear that language is and how you need to draft the policy to make it clear. And I would also state that the Hauser case, the ones that place bodily injury to one person in quotes, that helps us because they could have done that if they wanted to make only one possible interpretation be conveyed by this language.
Bodily injury here was to one person was in quotes. Do you think that makes the difference?
I think it does. I think that makes it clear and unmistakable that there is only one reasonable construction, because you're creating a special term then that when you plug in, when you go back to the previous section where it says bodily injury to one person, now you have to plug in there, apply there, damages for care, loss of consortium. That they're saying the most we will pay is for damages for care, for loss of consortium, for loss of services for anybody. Then that makes sense. But it doesn't when bodily injury can mean loss of consortium and loss of services, because you go back to the previous sentence, and now it's saying the most we will pay for loss of consortium, which is a bodily injury, is the per-person limit.
Okay. All right, you're down to 30 seconds.
If there are no further questions, then I will conclude.
All right, thank you.
Thank you.
The estate just conceded that if it was in quote, if those words bodily injury to one person was in quotes, then it would be okay, which is the argument that I made previously. They fail to explain how taking it out of quotation marks changes anything at all, because bodily injury is still a defined term to one person. Judge,
Would you agree bodily injury to one person quotes would be at least clearer?
I don't think it's necessary at all, and I also would say that whether it's clear or not doesn't make this ambiguous at all, so I don't think that any change is needed. I actually don't think it changes the result here, because the terms are defined. As Judge Sasso, you asked a question early on about wouldn't it require a separate definition, and that's exactly the point. If you accept the estate's interpretation, you would have two different interpretations. The
Let me ask you,
dissent,
is there a definition anywhere in the policy of the word damages?
I don't believe there's anything beyond that. I hesitate to answer that conclusively without looking at it.
I'm not aware of it, I'm just,
I don't think so. I'm looking at, give me a second, let me just double check in the definitions. There is not a definition of damages that I'm seeing.
You can take a moment to browse through the 105 pages of the policy.
I'm looking at the page with definitions on page 218 of the record, and there is not.
what do you think your best case is?
I think my best case is the Hart case that we relied upon. I think that the Cloacy case, and frankly, all of the cases that we've cited in Florida that all say that in order to have a bodily injury, you must have physical injury, and loss of consortium is not part of that. When the policy is read as a whole, which is I think what the court's questions were going to of opposing counsel, when the policy is read as a whole and you start with the definition, which is very clear, undisputed, and then you go through the language of this policy, it is very clear and there is no ambiguity at all. The estate comes up with a lot of tortured responses to try to make it be something that it's not. We would ask that the court find, consistent with all of the case law that has interpreted this, that loss of consortium is subject to the same per-person limit for the one person who has suffered physical injury, and that any other result would affect a real sea change in the law of Florida, which is not at all what was intended. Thank you so much.
All right, thank you both. All right, court will be in recess.